constitutional attorney. I'm here to talk to you today about the National Defense Authorization Act. There's been a lot of controversy about Sections 1021, 1022, and that's because of the great ambiguity in this language. I hope to clear up any questions that you have and shed some real light on the real meaning of these sections. What are the arguments in favor of this bill? Why are these arguments false? What are the problems with the language, and what are the solutions? These are some of the things that we'd like to walk through today so that everyone will have a very clear understanding of where we are in Sections 1021 and 1022. Section 1021 reads the affirmation of authority of the armed forces of the United States to detain covered persons pursuant to the authorization for use of military force. The very important phrase in that title is covered persons, and that's where we're going to start today. Section A starts out by reaffirming the authority of the President to use all necessary and appropriate force pursuant to the authorization for use of military force, which includes the authority for the armed forces of the United States to detain covered persons. Section B of Section 1021 then helps us understand what a covered person is. This is one of the areas of ambiguity and one of the areas where the argument in favor of this bill falls apart. Section B says, a covered person under this section is any person as follows: a person who planned, authorized, committed, or aided the terrorist attacks that occurred on September 11, 2001, or harbored those responsible for those attacks. Now that sounds pretty clear, and that's pretty concise about who is a covered person, but let's continue on then with Section 2. A person who was part of or substantially supported Al-Qaeda, the Taliban, or associated forces that are engaged in hostilities against the United States. Now we're getting a little shifty there because now we're engaged in hostilities against the United States or its coalition partners. Now, this next phrase in Section B is where the real ambiguity of this section comes in and the whole thing really falls apart. The phrase after the comma, the phrase after the words coalition partners are what really should draw concern for us, because it continues by saying, including any person who has committed a belligerent act or has directly supported such hostilities in aid of such enemy forces. These words are not defined anywhere in this act. These words are open, they are ambiguous, and they leave a great big hole for interpretation. The words any person, the words belligerent act, and hostilities. Now we have opened the definition of covered persons to any person who commits a belligerent act or a hostility. Section C of this provision deals with the authority invested in this section. It reads, disposition under the law of war. The disposition of a person under the law of war as described in Section A, which is our covered persons, may include the following: detention under the law of war without trial until the end of the hostilities, authorized by the authorization for use of military force. Now here is where we have the indefinite detention provision. You are now allowed to detain any person who has engaged in a belligerent act or hostility without trial until the end of such hostility. Section 3 of this same subsection C continues by saying that the authority now invested allows for the transfer for trial of these detained people to an alternative court or competent tribunal having lawful jurisdiction. What that means is that we are now trying these people, these covered persons, which are any person engaged in a belligerent act or a hostility. We can detain them indefinitely without a trial, but we can also transport them anywhere as long as they're deemed to be an alternative court or a competent tribunal. That means that we can transfer them outside the United States if they're detained here in the United States. That means they don't have to be prosecuted in a military court. As a matter of fact, the words competent tribunal are a very common phrase when referring to UN international courts. So are we now saying that this Section 1021 authorizes the unlimited detention of any person who's committed a belligerent act or engaged in a hostile activity, and then we can transport them anywhere to be tried in any court, whether foreign or domestic? At this time, I think it's really important to remind ourselves what our own Declaration of Independence says. For depriving us in many cases of the benefit of a trial by jury, for transporting us beyond the seas to be tried for pretended offenses. Now, as we look forward in this 1021, take a second to reflect on what we've done. There have been no exclusions of U.S. citizens. There have been no mention of any exclusion of U.S. citizens. And it is not limited to Al-Qaeda or Taliban, as we've seen. It is only limited to any person who has committed a belligerent act or a hostility against the United States or coalition forces or have aided such hostilities. Subsection D is where our congressmen are standing today to defend their support of this bill. Subsection B reads, nothing in this section is intended to limit or expand the authority of the President or the scope or authorization for use of military force. The problem with this is, yes, the language says it doesn't expand, it does not limit or expand the authority of the President, but we don't need to expand the authority of the President because that authority was already expanded in the Patriot Act. The Patriot Act allows for federal agents to seize property and persons and records without a warrant, without probable cause, based on mere suspicion with no review of a judge to create this warrant. These are literally what we call handwritten warrants, and they are arbitrary power. Let's move on to Section F of 1021. Now remember, we are still dealing with these covered persons. Any person who has committed a belligerent act or a hostility against the United States or its coalition forces, or materially supported anyone who has engaged in a hostility. Section F should bring forward a question mark in our minds. Section F reads, requirement for briefings of Congress. The Secretary of Defense shall regularly brief Congress regarding the application of authority described in this section, including the organizations, entities, and individuals considered to be covered persons for purposes of subsection B2. The question that should come to our mind is, why do we have to have a requirement for the Secretary of Defense to regularly brief Congress as to how this definition of covered persons is being applied if the definition is so clear and static? Because it's not clear and static. Because it's any person who is engaged in a belligerent activity or a hostility or is associated with someone who has committed a belligerent act or a hostility. We can now move forward to section 1022. When you are analyzing a law, you must understand that when you change sections, the rules change. And each section has their own set of rules. Section 1022 is now a new section with a new set of rules. This is where one of the fallacies of congressional argument comes forward. Many, many times when you hear the congressman defending their support of this bill, they will tell you that Section 1022 makes such requirement for detention inapplicable to U.S. citizens or U.S. lawful resident aliens. But that word inapplicable is nowhere in Section 1022. That word inapplicable is contained in the CRS summary, which is not the bill language at all. The CRS summary is supposed to be like an overview of the bill, a quick look table of contents so that anyone who wants to read the bill can read through the summary, find out which section they want to look at, and then go forward and read that section. Unfortunately, the CRS summary in this case is being used by many who supported this bill as the actual language of the bill, and it absolutely is not. The CRS summary reads for Section 1022, this requires U.S. Armed Forces to hold in custody pending disposition of a person who was a member or part of Al-Qaeda or associated force and participated in the planning or carrying out an attack or attempted attack against the United States or its coalition partners, authorizes the Secretary to waive such requirements in the national security interest, makes such requirement inapplicable to U.S. citizens or U.S. lawful residents. Now, the problem with this is multifold. Number one, it does not mention the sections that we've already talked about in 1021 about pulling in any person. And it completely misstates the section in 1022 that addresses the U.S. citizen detention. It says the requirement is inapplicable to U.S. citizens. That is not what it says. Let's go ahead and read now the section 1022 title and then subsection 1. Section 1022 title is Military Custody for Foreign Al-Qaeda Terrorists. Now remember, when you read a law, the section titles tell you who you're dealing with. So you know now, in Section 1022, we are dealing with foreign Al-Qaeda terrorists. There was no distinction in 1021 between foreign and domestic. But in 1022, we now are dealing with simply foreign terrorists. Subsection 1 reads, except as provided in paragraph 4. Now we're going to discuss that because that paragraph 4 is very, very important. The armed forces of the United States shall hold a person described in paragraph 2, which is going to be our covered persons, who is captured in the course of hostilities. Ooh, there's that word again, hostilities. Authorized by the authorization for use of military force in military custody pending disposition under the law of war. Something that should really concern us now is this mingling of these words, hostilities and war. Are we engaging in war? Are we responding to war? Are we responding to hostilities? What about this mingling of hostilities and war? That should concern us because, number one, in order to declare war, you have to have congressional act. You don't have to have any type of authority to call something a hostility. Now, we can move on to Section 2, which is now our definition for covered persons. Remember, we're still in Section 1022 that deals with foreign terrorists. foreign terrorist covered persons. The requirement in paragraph 1 shall apply to any person whose detention is authorized under section 1021 who is determined to be of or part of Al-Qaeda or an associated force that acts in coordination with or pursuant to the direction of Al-Qaeda, and to have participated in the course of planning or carrying out an attack or an attempted attack against the United States or its coalition partners. We're pretty clear then that these are foreign Al-Qaeda terrorists. But what about that limitation mentioned that Section 4, except in Section 4, the previous paragraph said? Well, let's read Section 4. Section 4 says, a waiver for national security. The President may waive the requirement of paragraph 1, which refers to paragraph 2. So when you're interpreting a statute, when a paragraph refers to another one, they pull them all into the same enforcement. So basically what this is saying is, the President may waive the requirement of paragraph 1 to include paragraph 2 if the President submits to Congress a certification in writing that such a waiver is in the national security interests of the United States. What that paragraph does is gives the President of the United States the ability to waive and alter the definition of a covered person without any limitation whatsoever if he deems it to be in the national security interests of the United States. Another argument you'll hear from those that supported this law is that the law that was passed is fundamentally different than the law that was initially proposed. Well, I don't know about fundamentally, but there are a few differences. So let's talk about those differences. And one of those differences actually falls into Section 4, the waiver for national security. The original bill submitted said, the Secretary of Defense may, in consultation with the Secretary of State and the Director of National Intelligence, waive the requirement of paragraph 1 if the Secretary submits to Congress a certification in writing that such a waiver is in the national security interests of the United States. A waiver in the original bill submitted had to be given in consultation of 3 people. 3 people had to come to the conclusion that a waiver was necessary for the national security interests of the United States. But the bill passed says the President may waive the requirement from the hands of 3 to the hands of 1. Now, another thing that we really have to be aware of, this says the President may waive the requirement of paragraph 1 if the President submits to Congress a certification in writing that such a waiver is in the national security interests of the United States. Nothing in paragraph 4 requires a vote of Congress, requires an approval of Congress, requires any type of congressional oversight whatsoever. All it requires is something in writing from the President that this is necessary, and then it's done. Now remember, we are still in Section 1022. Foreign terrorists. This is where we find the language that those that support this law hang their hat on. The applicability to United States citizens and lawful resident aliens, subsection B. This language reads, United States citizens. The requirement to detain a person in military custody under this section does not extend to citizens of the United States. The requirement to detain does not extend When you tell an administrative agency they are not required to do something, you're giving them a choice. They can choose whether to detain or not to detain. This is not exclusionary language. The proof of this is we have already laws in place with exclusionary language. If they wanted to, without a doubt, exclude U.S. citizens, the language already existed in previous law. They could have simply cut and paste. Now remember, this is foreign. This has nothing to do with 1021, the any person, belligerent act, or hostility. These are foreign, but it also, remember, in foreign was the subsection 4 waiver by the president. Okay? So that's how you can get U.S. citizens in here. Remember the CRS summary that said it makes the requirement inapplicable to U.S. citizens? Now we have the actual language which says the requirement to detain a person in military custody under this section does not extend to U.S. citizens. That is a one-sentence statement, replaced by a one-sentence statement in the CRS summary that does not even accurately reflect what the law says. Inapplicable is nowhere close to being not required. How could they have made this language clear? Like I said, the language already exists in law. When bill writers sit down to write bills, they don't reinvent the wheel every time they do it. What they do is they take language from laws that already exist because they're tried and true. They know that they will withstand legal argument. They could have done that with this bill. Remember, the section says the requirement to detain a person in military custody does not extend to U.S. citizens. What about the Civil Rights Act of 1964? That law has been on the books for a long time. That law says that you cannot discriminate against a person for hiring practices based on their religion, their race, their gender. But there's a section in there, section 2000 E2E2, which sets up an exception for churches and religious organizations and private clubs. Because if you're a church and you're going to hire a pastor, you're certainly going to want to discriminate based on religion. And sometimes you're even going to discriminate based on gender. So in order for the Civil Rights Act to comply with the First Amendment, they had to incorporate an exception in this law. The exception says, it shall not be an unlawful employment practice for these churches, religious organizations, and private clubs to discriminate in these ways. Shall not be. In the legal world, when a judge sees the words shall not, it means he has no choice. So, the requirement to detain does not extend, leaves a choice. But shall not extend to U.S. citizens is legally exclusive and leaves no choice. Now, this is not the only language that our bill makers could have used in this section. Another example of exclusionary language exists in our vaccination laws. Every state has a law requiring vaccinations. Almost every state has a section in their vaccination laws that excludes certain groups of people. Groups of people who would be medically damaged by vaccinations, or groups of people who do not believe that vaccinations are in line with their religious beliefs. So now we have laws with another section that excludes groups of citizens. In Florida, is Florida Statute 1002.20, subsection 3b. And it reads, "The parent of any child attending a public or private school shall be exempt from school immunization requirements upon meeting the exemptions in accordance with the provisions of the section." Shall be exempt. The requirement to detain does not extend, still leaves a choice. But when you tell someone that they shall be exempt, U.S. citizens shall be exempt, is legally exclusive and leaves no choice. Nobody had to think it up. Nobody had to invent it. It existed right there in existing law. So let's summarize here just a bit. Does Section 1021 exclude U.S. citizens in any way? There is no statement in 1021 that excludes U.S. citizens in any form or shape. As a matter of fact, Section 1021, it brings in any person who has committed a hostile or belligerent act. Does Section 1022 exclude U.S. citizens? No, it does not. Section 1022 says they're not required to detain U.S. citizens. That is not an exclusion. And it also incorporates paragraph 4, which allows the president to waive any requirement of a covered person if it's in the interest of national security. So this bill does not exclude U.S. citizens. It does not have to change any existing law because the Patriot Act is already seizing property and people without warrants. And it gives sole authority to the President of the United States to redefine who a covered person is. End the ambiguity, end the loopholes, end the arbitrary power that has been given in Sections 1021 and 1022 once and for all. This is what our founding fathers fought for. And if every single congressman that supports this law can stand in front of you and tell you it does not detain U.S. citizens because we didn't want to detain U.S. citizens, then they should be completely on board with fixing it so that there is no way that anyone with ulterior motives in mind can do the opposite. As a matter of fact, the President of the United States said in his press release that this bill gives the authority to detain U.S. citizens. He just was not going to use it. May I remind you of what our founding fathers said. Richard Henry Lee said, "Trial by jury in civil causes, trial by jury in criminal causes, and the benefits of the writ of habeas corpus all stand on the same footing. They are the common rights of Americans." And Thomas Jefferson wrote in our Declaration of Independence as a grievance against George III for detaining our founders. He said, "For depriving us in many cases of the benefit of the trial of jury, for transporting us beyond seas to be tried for pretended offenses." Chief Justice William Rehnquist said in 1979, "The founders of our nation considered the right of trial by jury an important bulwark against tyranny and corruption, a safeguard too precious to be left to the whim of the sovereign." I have never heard a better description of Sections 1021 and 1022, but to leave our fundamental rights at the whim of a sovereign. William Pitt said, "Necessity is the plea for every infringement of human freedom. It is the argument of tyrants. It is the creed of slaves."